Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today we're ending out our year of podcast episodes with our normal and have on Tiffany Lashmet from Texas A&M and myself to talk about some of the top legal developments in 2019 and what we can look forward to into 2020. This is our last podcast episode of 2019. I've already got a couple put together for 2020 to get the year started off. So we'll be back here with the podcast at the first of the year. So take a listen to what Tiffany and I put together earlier today. Oh, well, hello, Tiffany. How are you this
Paul.
week?
I'm good. How are you?
Pretty good. Pretty good for, what is this, Wednesday?
It is a Wednesday.
So it's not too bad. So for my listeners, how about you introduce yourself to the audience?
Absolutely. My name is Tiffany Lashmet, and I am an Extension Agricultural Law Specialist for Texas A&M AgriLife Extension. And so basically my job is similar to Paul's, except for that I cover the great state of Texas. But we do a lot of similar work as far as, different presentations, and we both have blogs and podcasts. And so very similar jobs to what Paul does in Maryland.
And for Tiffany's listeners, I'm Paul Geringer. I'm the Extension Legal Specialist here at the University of Maryland. And yeah, I do the same thing Tiffany does, only in a smaller state with less airplane miles accumulated over a year trying to get to meetings.
That's exactly right. That's a good point. Well, Paul, we're glad to be back. This is, I think, our third year in a row to do our annual Ag Law Year in Review for our respective podcasts.
Yes, it is. So, yeah, our podcasts have existed long enough to do 3 of these. I guess that's a major feat.
It feels like it. It feels like it should be. And folks that have listened before will be interested to see that we still have certain repeat offenders on our list of topics, but we do have some new topics this year, which will be fun to talk about.
Yeah. It's always nice when we get to mix it up with new things and it's not just all the same stuff over and over and over again.
Right, for sure. Well, let's start off, Paul, with what you and I think both would say is kind of the biggest ag law story of the year. You're going to talk to us about hemp.
Yeah, so hemp. We all know how excited people are out there to grow hemp. Starting to look at it. I'm assuming producers in Texas are ready, willing, and able to put a crop in the ground next year. The same producers are here in Maryland. Except I guess we got to put a crop in the ground this year through the research program, and you guys didn't have the research program in place.
Right, we're still waiting. Yep.
Yeah, so the 2018 Farm Bill has made all of this possible, looking at the fact that now hemp, or at least hemp with less than 0.3% THC, is now exempt from the Controlled Substance Act. It's no longer a Schedule I drug that DEA has to crack down on. And it's free for producers to produce it as long as their state has either an approved plan looking at the current regs and the way the law is written, an approved plan with USDA, or USDA has come in and approved a plan for the state to be able to produce hemp. And I believe there's some requirements with some of that. I don't think we really need to go into all the basic details of that, but it will require basically producers to put their land on file and some testing that will take place by the state. And I believe we're looking at total THC content and not some of the other THC testing regimes that states had been allowed to do under the 14 Farm Bill with the research programs. So we're looking at, how is this going to impact the industry and some of the other legal issues that are going to develop around this. I mean, we both were at the American Ag Law meetings last month here in beautiful Washington, D.C. And how many hemp sessions do we have, Tiffany?
It seems like every breakout session, hemp was an option. And those, a lot of times, were standing room only.
Yeah. And I know with our bar association coming up this year, or not this year, next June, we're looking at a hemp session for our ag law section and focused in a lot on intellectual property issues with hemp. But I know moving forward, some of the big legal issues are going to be, and I know both of us are working on this, is sort of the contracting issue that's associated with this. How do you develop a production contract for this crop? There's crop insurance issues with this. How do you insure crop that can potentially become a drug at any moment based
Well, and
on
I think,
THC levels?
and that's what I was going to say. I mean, to me, sort of the two biggest takeaways, and like you say, right, we're waiting to see, at least in Texas, we're going to have a state level plan. And so until that plan is out and has been approved by the appropriate officials at both the state and federal level, there's not a lot we can tell you about, exactly how that's going to work, the nuts and bolts. I think probably kind of the two biggest things that I tell people, number one is we still got a long road to hoe before we're ready for anybody to be planting hemp in Texas, right? So it's not like everything's good to go. We're ready to plant. There's a lot we still have to do, like getting that plan submitted to the USDA, getting approval for that at both the state and federal level. Then they'll have to start a licensing process. You'll have to get the license and jump through some of those other hoops. The other thing I always mention is what you just said, Paul, the idea that, right, if a crop goes hot, as they call it, right, where if the THC level gets too high or above the allowable limit that's set under the state plan or the federal plan, if you're in a state that's not going to have a state level plan, if your crop goes hot, you're required to destroy it. And the destruction thereof has to actually be done by DEA agents. It's not like the farmer can just do it, because then it's an illegal substance. And so, when you think about, look at some of the numbers that I've seen talking about, the kind of astronomical costs per acre to plan to grow hemp, and you have the threat of it potentially just being hot and being destroyed. There's a lot to think about there, I think, before you start buying seeds or plants and put them in a field.
Yeah, exactly. Yeah, you bring up a good point that right now we just know what the regs say. We have no idea what states are going to do. I don't even know if Maryland's going to submit a plan, what the plan is. If we're going to fall under USDA. I have no idea what the resources available in the state are to do that. And luckily, that's not my job to figure out.
Right. Well, like you say, just what I would tell people, no matter what state you're in, do some research. Make sure you kind of understand what is coming down the pike, what you need to be aware of. And then, like you said, Paul, I think those contracts are going to be so important, especially in an industry where, supply and demand is changing, where price structures are changing. I think having a good, solid production contract, purchase contract, with a set price is going to be really important. And I sure worry about people that maybe don't have a contract or don't pay attention to the details of their contract. I think they could get themselves in trouble if they're not really careful and trying to get themselves the best legal protections that they can.
Yeah, exactly. And the biggest thing we really don't even know the other answer on yet involving hemp is what FDA is going to end up doing with it, especially when we're looking at the CBD market, as to how are they going to regulate this, because they've already come out and said they plan to regulate it, but we don't know how yet.
Right.
So yeah, there's a lot of unanswered questions in this field, and I'm sure next year when we do this again, if we do a fourth one of these, I bet hemp's on there again.
Oh, I feel certain that we'll be talking about it for a while.
Yeah. So let's move on to another topic that seems to never go away, or hasn't, at least for the past 4 or 5 years.
4 or 5 years.
Yeah. So Tiffany, what's going on with the waters of the U.S. definition? Where are we at with it?
Right. For agricultural lawyers, WOTUS is the gift that keeps on giving, I guess. And it's still an issue, right? How, under the Clean Water Act, how do we define the term waters of the United States? And just brief summary, the reason that matters, right? The reason that everybody cares so much about this is the scope of the definition of waters of the United States is going to impact who's required to get a federal NPDES permit under the Act. And so it's a big deal, right? How broadly or narrowly that term is defined. This year, things have been interesting, as it has been for several years, and I'll skip a lot of the background. One of the big things that happened this time last year is the Trump administration put forth its new proposed definition of waters of the United States. It came out right about this time last year. Comments were taken on that rule through April of 2019. We still have not seen a final rule come out yet, but we're waiting on that. There have been several courts in the country that have looked at the 2015 WOTUS rule, of course, that was drafted by the Obama administration, and several courts have found that to be illegal or have violated certain principles of the law, like the Administrative Procedures Act. The most recent one of those, and kind of the most detailed opinion, came in a case called Georgia versus Wheeler out of the Southern District of Georgia, which held that 2015 rule was procedurally and substantively invalid. Where we are now is that the Trump administration had issued a final rule rescinding the 2015 rule. If your head is spinning at this point, I understand, because there's a lot going on here.
Oh, my head is spinning because I hate WOTUS.
I know. Well, Schoolhouse Rock, when they talked about the administrative process, didn't teach us how this would play out. So what we've got now is the 2015 rule has been rescinded by a new rule. Okay, and as of December 23rd, barring any sort of injunctions or court actions we can't predict, okay, as of December 23rd, the 2015 rule will no longer be effect anywhere in the United States, and every state in the country will be back to the sort of pre-2015 WOTUS rule, which, of course, that's what led to all the litigation and gave us the Rapanos opinion. So that's kind of where we are. Certainly, I think that we're going to see lawsuits no matter what the final Trump rule says. I assume we'll see that final rule come out in 2020. I also assume that we'll see a flood of lawsuits and predict that we will be back talking about WOTUS again in 2020.
Yeah, I assume we will be. And the other magical thing that could happen is, what if we have a new administration?
Sure.
January 20th, 2021, and where are we going to be at that point with it?
Sure, right? Because then do they scrap all of the Trump rule and start over again? I mean, it could just be a revolving door of that. We sure don't know at this point.
Yeah.
Okay, Paul, another topic that has been in the news a lot that I think people potentially have questions about, or at least want to sort of be aware of, is the litigation regarding Roundup. Talk to us about that.
Yeah, so I wouldn't say it's so much in the news, but if anybody's listening to this and, sitting at home watching daytime television in between, I mean, you will see a lot of ads for the Roundup litigation. And have you used Roundup? And do you have potential claims that could be settled in a class action lawsuit? We've seen a lot of jury verdicts in this, really in state court in California to start out with. I believe some of them have been at least, 80 to 90 million. I don't have the exact numbers. The one that got the most news this year was the one that had $2 billion worth of damages associated with it. Now, that was later reduced. That was a jury award of $2 billion. The judge later reduced it down to about $87 million. So they did not get all of the money that the jury had awarded. And some of that has to do with state laws, typically limit punitive damages, and juries have to be pulled back a little bit sometimes in jury verdicts, because we're going to talk about other cases, I guess, here in a little bit that have had high punitive damages claims too. But the main idea is that Roundup is defective when it's used, that it causes cancer or other forms of cancer like lymphoma and things like that.
And at least those are the allegations, right, that have been brought in those lawsuits.
Yes, those are the allegations.
We're not scientists, so we're not speaking to whether or not any of this is accurate or not, but those are the claims in the lawsuit.
Yeah. As I give a presentation about this in Maryland, and the first thing I say is, I'm not a scientist. I'm just telling you what the plaintiffs are claiming in these lawsuits. I make no deals. And in that, when we look at it, currently the major focus has been in Bayer / it's Monsanto. Bayer bought Monsanto within the past 2 years. This is not litigation. It was expecting to take on. Some of the issues around this have stemmed from the fact that recently, within the past 2-3 years, the World Health Organization came out and said it's potentially a carcinogenic product. EPA, in looking at this, has said, no, it's not. As long as you use it according to the label, it's not a carcinogenic. There's no reason you should be getting cancer if you use this thing appropriately. So some of this is coming from, we have competing expert agencies telling us different things. So this is feeding some of these lawsuits as to what's causing them. Currently, if I remember right, there's about a couple thousand class action or suits filed as a part of this class action lawsuit in the Northern District of California. They're currently all under mediation. I believe the two most recent cases I saw that were supposed to be starting in federal district court in Missouri are currently on hold to help continue the mediation process. And I've seen news reports that Bayer is looking to get out for a couple $1 billion out of this litigation mess that it's found itself in by the purchasing of Monsanto. So we don't know exactly what's going to happen, how things are going to play out, especially in the mediation and the settlement process that may be going on behind closed doors that none of us are really aware of, any of those details. The main thing that needs to be taken into account, and I think both of us get these questions a lot, is, what happens if a farmer sued? What happens if a landowner sued? And I think the basic takeaway point from this is, make sure, especially if you have farm workers, you're providing them with the proper equipment to use Roundup. They're trained in how to follow the label appropriately and use it appropriately according to the label. They're not cutting corners in any way when they're using it. If we look at some of the claims, there may have been issues where the label was not always followed at all times, and that's what's led to some of the health issues. Again, we're not doctors. We don't know what actually caused some of these illnesses, so don't think we're trying to blame people for what happened to them. And also at the same time, probably because of this lawsuit, it's a good time to check insurance policies to make sure if you are sued, does your insurance provider cover you in that lawsuit? Do you need to buy a rider? If you're a landowner and renting to a farmer, do you need to put in lease provisions that at least say the tenant will follow the label with all chemicals applied on the farm, not just Roundup? Because if we think about it, this isn't just a Roundup issue. It's potentially a bigger pesticide issue to where we would think about how we maintain being able to use these pesticides and limit lawsuits. And also, do we put in provisions in the lease that basically say the land or the farmer will indemnify the landowner if one of these lawsuits happen to that individual farmer and the landowner's brought in? These are a lot of things I think we need to be thinking about as an industry, just to how to limit some of the damages that could potentially be associated with this if the focus goes away from Bayer and Monsanto.
Yeah, I think that's a really good point all the way around. So next up, let's go back to the Clean Water Act, Paul, because apparently it's my favorite topic, and I'm going to go again.
You love this, don't you? You just love groundwater as a conduit.
It really is a fun topic. And so this issue, it still revolves around the Clean Water Act, although not about the definition of WOTUS. But essentially the question here is, under the Clean Water Act, right, the background is if there is a discharge from a point source of a pollutant into a water of the United States, you have to get a permit. And so there's no question, right? If you've got like a pipe that dumps pollutant into the Pacific Ocean, you have to get a permit. But the question came up, what if the discharge is indirect? So what if instead of the pipe dumping pollutant into the ocean, the pipe pumps the pollutant into the groundwater, but you can use like a tracer dye and prove that it ends up in the ocean? Do you have to get a permit for that indirect type discharge? And this really came to a head this year in November when the Maui County versus Hawaii Wildlife Fund case was argued at the United States Supreme Court. And that's the question. The county of Maui had some of these injection wells. They were pumping effluent into the injection wells, into the groundwater. It made its way into the Pacific Ocean. And the Hawaii Wildlife Fund filed suit saying, hey, you need to get an NPDES permit. The county's position is, no, we don't. That only applies to a direct discharge. And so I think it'll be really interesting to see what the Supreme Court will do. A group of us from AALA got to go to the oral arguments at the Supreme Court, which was an awesome experience. By the way, I'd highly recommend that if you ever get the chance to go. Kind of the prediction from everybody was sort of the same. We think that the justices really struggled and didn't love either of the two tests that the parties put forward. And so we predict that when this opinion comes out in 2020, we may see some new test that's kind of in the middle as to how to deal with this. But I think the big takeaway here is this potentially has impact on the agriculture industry because it's broader than just these injection wells in California, or I mean in Hawaii. We've seen the cases with the same argument involving coal ash ponds, where there was pollutants seeping into the groundwater from the ponds. We've seen this argument come up when a pipeline ruptured and oil got into the groundwater and then ended up in a lake. So I certainly see when we're looking at agriculture, gosh, if we had a legume, could they make this argument? If we were applying fertilizer or manure on a field that got into a groundwater and ended up in the river, could they make this argument? And so I think one that does really have the potential to impact agriculture, and I think an opinion that we really want to keep an eye on in 2020 from the United States Supreme Court.
Yeah, that's a good point. This could have major implications, and we'll probably be back here next year talking about it yet again.
Right. Yeah, we for sure will, right? Because, I mean, we in all likelihood will have an opinion from the court. Unless something crazy happens, we'll have that opinion by June. And so I predict that will be on our list of things to update you on in December 2020.
Yeah, so I guess.
Okay, Paul, another ongoing issue that is of huge importance to agriculture and also one of our favorite topics in general is right to farm. Tell us a little bit about what's going on with that around the country.
So I think the biggest things that we have to look forward to or have seen in, this year and moving forward into 2020 are, if everyone remembers, we've talked about, I think last year at this time as well, we talked about the North Carolina hog farm litigation involving, a large number of hog farms in North Carolina. None of the hog farms are being sued. It's all Murphy Brown, which is a live grow out arm of Smithfield Foods, being sued in federal district court there in North Carolina. And early on, and I believe this was actually 2 years ago when this ruling came out, was that the judge in the case ruled that the right to farm law did not apply in that case because the people had been there before the hog farms were established, or most of the residences had been there before the hog farms were established. That we could look at the fact that because there wasn't this change in condition that North Carolina required, the right to farm law didn't apply. And for those that don't remember, right to farm laws are nuisance defenses that farmers can use to prevent neighbors from being able to sue them for causing nuisances. The biggest development there has been that some issues have been removed to allow appeals in that case. And I believe the appeal, at least involving the right to farm issue in that class action litigation, will be in late January of next year, correct? If I remember what I've been told correctly.
Okay.
And then I think the only other really big right to farm case we had was out of Indiana,
right,
involving a hog farm that had been established. About the time the doors opened on the hog farm, the neighbor sued for nuisance, and the court kind of looked at it and agreed that the right to farm law defense was not unconstitutional for the landowners or for the farmer owning the hog farm to use. And I think the biggest development out of that was sort of some of the strategies sometimes are to wait and utilize nuisance lawsuits to sue some of these operations. And the court looked at it and said, actually, you should do a lot of this in the permitting process. If your state has a permitting process and neighbors are allowed to comment and request hearings, maybe you should do it then instead of waiting for the nuisance lawsuit after the farm's established to be able to do this. And in that case, the judge looked at it or the judges looked at it and said, if we looked at this, none of the non-ag people moved in till the late 70s. The area had been agriculture for, a long time at that point. And it wouldn't have been a nuisance if the farm had started, a hog farm whenever it was established, which I believe was either in 1930 something or 1940 something. So the court kind of rejected most of the nuisance claims there. And at this, I'm trying to think if there was anything else. I think that's a major developments out of that case.
Yeah, and just in general, right? Because those right to farm statutes do differ around the country. We've seen some legislative changes to some of those. What I always tell people at programs on that is, hey, you need to make sure you're aware that your state has one of these, right? Understand if you face a nuisance lawsuit that there is that protection. Take a look at it. Make sure you understand the provisions. Make sure you're doing what you need to do to comply with them. And again, they're different in every state, but that's a really important protection for ag producers to be aware of.
Yeah, and that's a good point. That's usually what I remind people too, is like, look at the law and make sure you're in compliance with the law, because if not, you're not going to get this defense, and it's going to create more problems.
Right. And you want to be proactive because there may be things that you need to be doing now or documenting now in order to make that defense be effective when you need it. So I sure recommend folks look at those right to farm statutes in their own state.
Yeah. And now, Tiffany, another issue that never seems to go away.
Yeah, the beef checkoff litigation that is going on is a issue that sort of started in this iteration of it started in Montana when RCAF filed a lawsuit in district court in Montana challenging the checkoff program there. And for those of you that maybe aren't in cattle production, and lots of other commodities have checkoff programs as well, but the beef checkoff requires a mandatory $1 a head assessment be paid anytime cattle are sold. And so, for example, right, if we're going to haul steers to the sale barn, we pay $1 a head. The way the Montana program is set up, 50 cents of it goes to the Cattlemen's Beef Board at the federal level, and the other 50 cents of that dollar goes to the Montana Beef Council. And RCAF argues that this requirement where they have to send money to the Montana Beef Council violates the First Amendment. For a variety of reasons. One of those is that they argue that the Montana Beef Council is a private entity and the government is kind of forcing them to support speech that they don't agree with. They don't like some of the Beef Council's advertising campaigns. They also argue that there's no mechanism to allow them to choose their full assessment be paid to the Cattlemen's Beef Board at the federal level, that they object to that messaging. And so there have been a number of developments in that case. One of the biggest ones is that the lawsuit was expanded to request a permanent injunction not only in Montana, but into 13 other states that have similar setups as far as their state level beef councils go. One of those is Texas. Maryland was not included in this list, but so far no other injunctions have been issued like there has been the one in Montana. But that is hanging out there, right? The potential of injunctions in these other states that have similar setups. So certainly something I think for the beef industry to be aware of. This could have big impacts on the industry. It could certainly have big impacts on the state level beef councils in those 13 states that could also be affected.
Yeah, and we could see major implications out of this to other commodity groups.
That's right.
Just on their checkoff programs. I'm thinking about corn and soybeans, and some of the other groups may have potential issues.
That's right. Yeah, there's a ton of different commodity groups in agriculture that have these type of checkoff programs, and I think you're exactly right, Paul. I think we could sure see implications from this that could be broader reaching than than just the beef program in those individual states. So that sort of wraps up what we're going to talk about on the federal level. I mean, there are probably a million other issues we could have chosen, but for the sake of time, we limited it a little bit to what we thought were kind of the most pertinent. But we do each have a case or a discussion point from our individual states. Paul, in Maryland, what is going on with this workers' compensation case that came out this year?
Yeah, so this is a recent development within less than a month ago this came out. So we have a poultry farmer who has been permanently disabled from being able to work on the farm he was employed at. He was a farm manager. And to give a little bit more background on this, he was originally hired by the original owner to just be a guy who worked on the farm. The farm owner showed him how to do everything on the poultry farm. And then within less than a year of being hired, the poultry farm owner passes away. He has a contract with Tyson. Tyson comes in and trains this guy how to operate the farm because the widow didn't know anything about poultry farming. About 2 years later, poultry farmer widow decides, I don't really want this farm anymore, and sells it to a guy who lives in Northern Virginia. So this is on the eastern shore of Maryland. So give or take, this would be about 4 hours away. And I can guess this is going to be an investment property for this person in Virginia. Tyson basically will only agree to continue the contract if the new owner keeps this guy on the farm, because part of the contract requirements require somebody to be on the farm 24 hours a day, 7 days a week, or at least be able to deal with issues that develop in a reasonable amount of time. And guy in Northern Virginia is not going to be able to probably handle that quickly based on traffic issues just to get to the Eastern Shore where this farm is located.
Sure.
So gentleman develops debilitating disease because of this and goes and basically goes and files a workers' comp claim because the landowner did not have any workers' compensation insurance on this farm worker. It goes to the uninsured employers and uninsured employees program within the state that I'm sure Texas has too. And they basically sue to include Tyson in on the lawsuit as well as the farm employee. And the main issue is this guy a co-employee of both Tyson and the farm owner? The Workers' Compensation Commission came out and said he is a co-employee. Then it is appealed by Tyson's to the district court on the county court on the Eastern Shore where this was located. And the county court comes back and says, really, no, it's not. This person is not a co-employee. And it's now been appealed up to the Court of Special Appeals in the state. We do not have a Supreme Court. We have a Court of Special Appeals and a Court of Appeals. And so the Intermediary Court of Appeals has ruled basically, yes, he isn't a co-employee. They looked at the fact that there's this relationship in the poultry production contract that allows the integrator / Tyson to have control over how the birds are raised. And they were providing this farm worker with a lot of assistance to understand what he needed to do, telling him what to do, everything. So the court, that looked like they had enough control to make him a co-employee of both parties. There's one dissenting justice in all of this, and he brings up a basic point that's never addressed in the majority opinion. Everything this co-employee or this guy that they're claiming is a co-employee did, he's actually the agent of the owner. So everything he did is just basically he's interacting as the agent. And that's never fully addressed. So the thought is Tyson will appeal this decision because it makes no sense, at least, that nobody's dealt with the agency aspect of this case. And it creates slightly more issues for Tyson. And it's been very hard to give guidance to sort of the poultry industry and poultry growers because the fact pattern of this case is just so weird.
Right.
With this farm worker. So, yeah. So that's kind of what's going on with that and could have implications outside of Maryland when we look at the poultry industry in other states. So, Tiffany, why don't you tell us about some pending cases in Texas?
Yeah, so in Texas, there are 2 cases that are currently pending at the Texas Supreme Court that could have major implications on agriculture, which is rare. I mean, it's kind of exciting to see that the Supreme Court's going to look at 2 ag issues. One of them is a fence law case called Garcia versus Pruske. And long story short, in that case, what happened is a bull was hit when he got out of a pasture. It was on a state highway in a county that has a local stock law. And so here in Texas, there's sort of 2 different standards. If animals are on a state highway, the standard a court would look at to determine liability to the owner is, did the owner knowingly permit the bull to run at large? In a county with a stock law, what a court would look at would be, did the owner permit the animal to run at large? So we've got a knowingly permit standard and a permit standard. Here, there's some argument amongst the parties about which one should apply. Not surprisingly, the landowner wants the higher standard of knowingly permit. The vehicle driver wants the lower permit standard, and we've never had this answered before. despite there being almost, not every, but the vast majority of counties this could potentially be an issue in. So the San Antonio Court of Appeals sided with the driver of the vehicle and said, yeah, if you could just prove permit, then you potentially have a claim. It could go forward to a jury. That question's been appealed by the landowner to the Texas Supreme Court. A number of agricultural groups have jumped in as amicus in that case in support of the landowner, saying, listen, there's a state statute that says it's a knowingly permit standard on state and U.S. highways. That's what should apply. There are some other factual issues here that I think are important, and it'll be really interesting to see how the court deals with those. But this could be a big one for fence law and liability here in Texas. The other big case that's pending at the Texas Supreme Court is a case called Swepco versus Lynch. That case deals with an old transmission line easement that was purchased by Swepco back in 1949. They built a transmission line on this property at that time and historically had used a 30-foot wide easement. In 2014, the company decided they wanted to modernize that line. They offered the landowners $1,000 if they would amend the easement to include a term that said the width would be 100 feet. The original easement didn't list a width, and so they were kind of trying to clean that up and secure this 100-foot easement. Well, the landowners basically said, no, we're not going to sign that, and we think your use should be limited to that 30-foot historic use, since that's what you've been doing for the last 70 years. Both the trial court and the appellate court sided with the landowners, and basically what they said is if you've got a general easement like this that's silent as to width, at least under these terms, right? There could be different terms that could change this, but a real basic one like this, once the location is selected, it becomes fixed and certain. And so you're limited to that 30 foot. Again, that's been appealed to the Texas Supreme Court. The petition for review has been granted. And looking at the number of old easements that are around the state, I think this one could have big impacts on Texas landowners, depending how that shakes out.
Wow. Those will be interesting to follow.
Yeah, for sure. And of course, I think it's good for us to mention, Paul, why don't we both plug the resources that we've got? Tell us about, for folks in Maryland especially, your blog and podcast, because if people are interested in these issues and want to follow up on them in the new year when something happens, that's probably the best way for them to do that.
Yeah. So my resources are, I have the Maryland Risk Management Education podcast because I do slightly more than legal outreach than Tiffany does. So it's at agrisk.umn.edu. And then my podcast is basically the Maryland Risk Management Education podcast. And I believe that's at marylandagpodcast.org. And Tiffany, what about your resources? Because I'm sure there's some folks even in Maryland that would like to follow up on some of the fencing law issues.
Sure. Yeah. So I've got a blog. It's called the Texas Agriculture Law Blog. You can Google that, or you can go to, it's agrilife.org/Texas Ag Law. And similar to you, Paul, some of it is Texas related. A lot of it's generally applicable if you're interested in ag law around the country. I think it would be helpful. My podcast is called Ag Law in the Field. You can listen to that on any of your podcast app, iTunes, Stitcher. You can also listen on your computer. The website for that is aglaw.libsyn. So that's LIBSYN.com.
Cool. Yeah. So I think we both cover a lot of national issues on both of our podcasts and blogs, and it's not just state resources, as you're saying. Yeah.
Agreed.
So anything else we need to talk about today, Tiffany?
Wow, that's about it. I appreciate you doing this again with me, Paul. Every year we have our standing podcast date in December. It's been a fun year, and it looks like 2020 is shaping up to be just as interesting.
Exactly. So we'll have to stay tuned to see what happens. I'm sure something new will come along that will just be added into this next year, and it won't all be the same thing.
Oh, I'm sure we can, buckle up, because I'm sure there'll be new issues to talk about by this time next year.
Hey, I mean, Syngenta settlement checks have now totally gone off the table. We don't even have to talk about that.
Well, hope springs eternal, Paul. That could raise its ugly head again.
Exactly. I knocked on wood as I said that. Thank you. Thank you for listening to this episode of the Maryland Risk Management Education Podcast. If you have any questions, thoughts, anything you want us to do on this podcast, please email me at lgoering@umd.edu, or you can tweet me at aglawpaul. Find me on Instagram at aglawpaul. I'm always willing to listen to what you guys want to hear on this site. I would like some feedback on additional issues that we should be covering on the podcast. Again, I will put all the resources that we talked about today, either Tiffany talked about or myself talked about, up in the show notes, just kind of in some headings so you can get some idea where these resources exist and learn more about the issues if you want to. Thank you again for listening, and enjoy the rest of your day.